Business Law Agency Part 2. Extinguishment of agency. The contract of agency is extinguished by keyword EDW Edward pala. The expiration of the period for which the agency was constituted, death, civil interdiction, insanity or insolvency of the principal of the agent, withdrawal of the agent, accomplish of the object or purposes of the agency, revocation by the principal and dissolution of the firm or corporation which entrusted or accepted the agency. The agency may also be extinguished by mutual consent of the parties by the loss of the subject matter of the agency or by operation of law. Revocation of the agency. As the general rule, the principal may revoke the agency at will because he is the source of authority and he is entitled to the full control over its continuance. The revocation may be expressed or implied. There is implied the revocation of the agency when the principal appoints new agents for the same business or transactions, provided there is an incompatibility of the first agent has been duly notified. The principal directly manages the business entrusted to the agent, and the principal gives a special power of attorney to an agent for a transaction which is included in the general power of attorney previously granted to another. Here, the special power impliedly revokes the general power as regards that particular transaction. However, the revocation to be valid must comply with the following requisites. It must be done in good faith, and it must be brought to the attention of specified third persons. As an exception to the general rule, the agency is irrevocable if it is stipulated to be irrevocable if it is coupled with interest. B. Obtained a loan from A amounting to 7 million. As security for the loan, P entrusts his cell phone to A and authorizes the latter to sell it if P will fail to pay his loan on the maturity date. In this case, P cannot revoke the agency at will because it is coupled with interest. If the bilateral contract depends on the agency, P appointed A as his agent to sell 1,000 kavans of palay. They agreed that A will store a palay in a warehouse. So A entered in a contract of deposit with X for storage of goods for which he paid 20,000 for a period of 6 months. The agency is irrevocable because the contract of deposit depends upon the contract of agency. If it is means of fulfilling an obligations already contracted. D has an obligation to C amounting to 100,000 payable on June 22, 2006. On a maturity date, C made a demand for payment but D has no money, so he offered to appoint C as his agent to sell his car and to apply the proceeds of the sale to his obligation. C agreed and the car was delivered to him. The contract of agency is irrevocable because it is a means of fulfilling D's obligation to C. If the managing partner is appointed in the articles of partnership, such appointment is irrevocable without just cause. Withdrawal of an agent. The agent may withdraw anytime by notifying the principal, but he must give the principal a reasonable opportunity to take the necessary steps to meet the situation. The agent shall be liable if the principal shall suffer damages by reason of the agent's withdrawal, unless it is impossible to continue the agency without detriment to himself. Take note that filing a case against the principal for monetary claim is equivalent to withdrawal. Death of the agent principal. Death of the agent extinguishes the agency because he can no longer carry out the business entrusted to him. In this case, his heirs must notify the principal and they must continue the agency and observe due diligence in protecting the interests of the principal until such time that the principal has caused the management of the subject matter of the agency. The heirs, however, cannot compel the principal to appoint them as a substitute agents because agency requires trust and confidence. As a general rule, the death of the principal extinguishes the agency because the source of the power or authority no longer exists. The agency, however, remains effective even if the death of the principal in the following instances. If the agency has been constituted in common interest of the principal and the agent. Jose obtained a loan from Mario in the amount of 100,000. Jose also appointed Mario as his agent for the sale of his car with the agreement that the amount of loan will be deducted from the proceeds of sale. In this case, the death of Jose will not extinguish the agency because it has been constituted for the benefit of both Jose and Mario. Number 2, if this agency has been constituted in the interest of a third person who has accepted the stipulation in his favor. Jose obtained a loan from Mario in the amount of 100,000. Jose appointed Danilo as his agent for the sale of his car and to pay his loan to Mario out of proceeds of the sale. Even if Jose will die, the agency will not be extinguished because it has been constituted in the interest of a third person, Mario. If the death of the principal is not known to the agent, anything done by him is valid with respect to third persons who have contracted him in good faith. Excuse me. Jose appointed Danilo as his agent for the sale of his car. On July 23, 2006, Jose died. Not knowing that Jose is already dead, Danilo sold the car to Mario, who is also unaware of Jose's death. The sale is valid even if Jose is already dead. Upon the death of the principal, the agent has still the authority to continue and finish the business already begun, and the death of principal should entail in any danger. Jose appointed Danilo as his agent for the sale of mangoes harvested from his farm to his client in Manila. When Danilo reached Manila, he received a text with information that Jose died. Danilo can continue to sell mangoes to Jose's client because a delay will certainly cause damage to his principal's interest, considering that the fruits are perishable in nature. However, if the heirs of Jose will direct Danilo to bring the fruits back to the province, he must follow the order.